Case for this session is Eimers versus Iowa Department of Public Safety. Good afternoon. And for the appellant, and am I pronouncing it right? Eimers? Eimers. For Mr. Eimers, we have Pam Walker. And for the state, we have Breanne Stoltze. Ms. Walker, whenever you're ready.
May it please the court. This case is about whether Trooper Eimers can bring a claim under Iowa Code Chapter 91A, the Wage Payment Collection Act, for Department of Public Safety failing to pay him wages as required under Iowa Code Section 80.6(4). Or is he precluded from doing so because he did not file a grievance under the collective bargaining agreement? And I really struggled with how to present this argument to the court because there are just so many little nuances throughout this, and it's been going on for a long time, that it's made it difficult as to what is going to be the most important for you. So I hope you ask me lots of questions so I can address your concerns. But anyway, there are two important facts to remember. One is that Trooper Eimers' claim is for wages not paid under 80.6(4). And the second one is that he is not claiming that there is a violation of the collective bargaining agreement. He has never claimed that there's a violation of the CBA. Based upon these two facts, so then was he required to file a grievance under the CBA? Well,
First fact that you mentioned, the wages not paid under the 80.64. And then I think the DPS's argument sort of focuses on that Kleppe case and that you have to like sort of make reference to the CBA to get to the wage claim. So how, I guess, sort of foundationally, how is this different from Kleppe?
well, I have had a hard time trying to articulate that as well, but his claim was for an issue or the dog handling that was covered in the CBA, and it wasn't covered anywhere else. That's not the case here. Trooper Eimers, well, this is about whether or not you have, what your pay is if you receive a work-related injury or are disabled because of a work-related injury. It is covered in two places, the CBA and under the Iowa Code, 80.64. So, and they conflict with each other. So then the question becomes, is the provision in the CBA even a legal subject of bargaining because it conflicts with an Iowa code?
Did you raise that issue before the district court and get a ruling on that?
It was raised. I'm trying to think of how it was addressed. I can't really remember anymore. But I don't think I addressed it as strongly there as I am now. I think I just mentioned that the two differed from each other and didn't add to it, so is it illegal? And here I'm just adding, so maybe it's illegal. So I would say that would be the difference. So it's not really a new issue. It's just expanding on one that was raised. So the two provisions differ quite a bit. The 80.64 is triggered when a doctor gives an opinion that the employee is unable to work and it is a work-related injury. Under the CBA, it's not triggered until the officer or trooper begins to receive workers' compensation benefits. What pay is received differs. Under 80.64, it's full pay and benefits. Under the CBA, the officer receives the workers' compensation benefits and then is able to supplement it by using sick leave or vacation leave, whatever the case may be, to bring him up to full pay. So under 80.64, so you can see why public safety prefers to pay under the collective bargaining agreement. It's because they don't have to pay as much money that way. You know, somebody else is, you know, footing the bill for the workers' compensation benefits, and the employee himself is paying for the sick leave because the sick leave is his, not DPS's. Reimbursement of sick leave should be given to the employee under 80.64 at the time of the doctor's opinion, whereas under the CBA, they're not reimbursed for any sick leave they took until retirement. The benefit ends for both on retirement or return to work. Another key part is under 80.64, all law enforcement officers and DPS are entitled to benefits and wages under 80.64, including the supervisors, so all the way up to the colonel. And under the, of course, collective bargaining agreement, it's just the line officers that get that benefit. And so the statute controls over the CBA, and if the claim is made under the statute, then there's no violation of the CBA. In fact, the DPS had been paying him as the collective bargaining agreement provided. But the only thing that happened was, contrary to what happens for most of the troopers, is they receive workers' compensation. Trooper Eimers was, we believe, very wrongfully denied his worker compensation benefits. So he didn't have any workers' compensation benefits to supplement. He had to use his sick leave entirely for his full pay. And he had to use it for a significant period of time because the POR board was being very slow about hearing his case, getting him to Iowa City to be evaluated and that type of thing. It took a year and a half from the time he applied until a ruling was received. He actually ran out of leave time before the retirement board made a decision, and an agreement was reached with DPS that they would continue to pay him his full benefits, but that it was understood it was not being paid under 80.64, and that if he was not given an accidental retirement by the board, he had to pay the money back.
If you're successful with your claim, what relief are you asking from this court?
Well, we're asking for one, that he be reimbursed for, well, we want him to, the damages are, we want it to be calculated what he would have been paid and received on retirement if he would have been paid as required under 80.64. So that would mean all of his benefits would have kept accumulating and he wouldn't have had to use any of them. And he would have received full vacation payout, holiday payout, and I think that there was some compensatory time too that he was owed. And what's ironic is that in failing to pay Trooper Eimers those items, DPS relies on 80.64 and says, well, it only requires the reimbursement of sick leave. So we don't have to reimburse all that other leave, so we're not going to do that. So
benefits issue submitted to the jury? It looks like there was just 4 categories of damages that were submitted to the jury.
I guess I don't understand the question of the retirement benefits. He received.
Or maybe I didn't understand your answer to my last question. So what is the relief that you're requesting?
We want his pay to be calculated as if he would have been paid appropriately from the time the doctor said, you can't work anymore. Okay. And so from that day for over a 1.5 year period of time, basically, so that he would have had his full pay, not had to take any leave time, and been compensated. And there's not a whole lot of difference, a little bit of difference though. And DPS acknowledges that they did not give him holiday pay or the compensatory time he was asking for. So that, and then plus attorney's fees and costs is a big item. So we would be asking for that as well. And I see that my time is up.
Have more time on rebuttal. Thank you. Ms. Stoltze?
May it please the court, counsel. My name is Breanne Stoltze on behalf of the Iowa Department of Public Safety. I want to start by clarifying what Mr. Eimers did receive prior to this lawsuit and what benefits are actually at issue. Then proceed through his grievance obligations under both the statute and the CBA and touch on the illegality inconsistency point. So to clarify, it's important to note that throughout this process, from the point at which he tested positive for COVID in January 2021 and his retirement in August 2022, Mr. Eimers continued to receive a biweekly paycheck. He then, upon his retirement, he received the maximum allowable vacation payout of 354 hours, as well as he was reimbursed for all sick leave that was used while his retirement application is pending. And that reimbursement of sick leave is consistent with Iowa Code Chapter 80.6 sub 4, which talks about, if some has to be used, it should be reimbursed. That occurred here. He also continued to receive longevity pay, cost of living adjustment, payment for uniform cleaning. And what really is at issue in this case are a couple of additional benefits that are created solely by his collective bargaining agreement, namely callback time under, I believe, Article 8, Section 9 of the CBA, and the accrual of holiday time, which is there, Article 9, Section 5. And, if we look at, even if we accept under Chapter 80.6, what he should have been paid, we're looking at, under the terms of that, what are the fixed pay and allowances? He's asking for those 2 types of fixed pay and allowances, but we can only determine what those are by virtue of looking at the collective bargaining agreement. Indeed, Mr. Eimers admits as much at page 4 of his reply brief, conceding that 80.64 does not define fixed pay and allowances, so you have to look to the CBA. And that puts Mr. Eimers, unfortunately for him, squarely within Iowa Code Chapter 20.18 and the grievance exclusivity provisions of his collective bargaining agreement. It's been kind of well established by this court that under 20.18, that if a public employee is covered by a CBA and the CBA sets forth grievance procedures, the employee is required to follow those procedures. That's Kleppe at star 4, Harrison at star 3, Hartunian at star 3. So
Hartunian cites to a couple other cases, Barsky being one of them, that plaintiff may assert rights independent of the CBA, that they're not giving up all of their rights. Why is Trooper Eimers, why doesn't he have a right under 80.64 independent of the CBA?
Because, as even Mr. Eimers admits, 80.64 turns on this notion of fixed pay and allowances. That's not independently defined under statute, the way perhaps certain rights under, say, the Iowa Civil Rights Act are defined. It's, what an officer's fixed pay and allowances are is going to be necessarily determined under the CBA. And that makes sense, as that's kind of what's commonly, the common purpose of a CBA is to kind of determine what pay and benefits are. Yep. And so kind of looking at that, so the question becomes then, obviously, we're not looking at everything under the sun. We're looking at, well, what does the grievance provision here say? And if we look at the language of the grievance clause there, in particular, Article 4, Section 6, that the grievance clause here is quite broad. It doesn't necessarily matter whether a violation was alleged, although we take the position that Mr. Eimers is effectively saying that the union or that the Department of Public Safety violated the CBA by not paying callback time and holiday time appropriately. But even if we accept this argument that we're not talking about a violation of the CBA, the language of the clause is much, much broader. It says, quote, that it's the exclusive procedure for, quote, any disputes arising from the application and interpretation of the CBA. So here we're kind of looking at what he's claiming, and again, it's this callback time, this accrual of holiday time. Those are creatures of the CBA, and this is why, frankly, this case is precisely like Kleppe versus Fort Dodge Police Department is the...
One thing that does differ from Kleppe, the kind of procedural posture of it, it's a little bit odd here that the district court granted the directed verdict on an issue that really wasn't even before the jury.
So I have to admit, I was not trial counsel, but in speaking with them, my understanding of what occurred was that in proceeding and preparing for trial, the understanding based on the language of the petition was that the dispute was really about how much sick time was reimbursed. And so it was really sort of how many hours were put in, were used between what dates. And the belief was, well, this would be put you outside the collective bargaining agreement, and that's why you had the motion in limine to keep the collective bargaining agreement out, because the belief was, well, that's not really part of this case. It was
Summary judgment.
because it wasn't made clear until the trial brief and pretrial proceedings that the actual claim was much broader, and at that point, the summary judgment deadline had passed. So that is kind of why you have this unique procedural posture here. And why the district court then looked at kind of then, given the facts, yes, we're at a different place procedurally, but factually we're at essentially the same place. As in Kleppe, we're talking about, well, what does the collective bargaining agreement say about canine training? Here it's, well, what does it say about callback time, which is, again, something that doesn't really exist outside the CBA. This notion as a police officer, you're called back for certain duties. Holiday time also operates differently than it does in kind of outside the public safety context, because you have a situation where public safety officers have to provide coverage 24/7, so they have kind of a different shift structure that affects how holiday is done. So both of those, to really determine whether there was a violation under Chapter 80.6, essentially, did he receive his fixed pay and allowances, you have to interpret and apply the CBA, which is the district court held to put you squarely under the exclusivity provision of the grievance clause.
Back to the kind of odd procedural posture that we have here, does that affect how we review the district court's ruling? Because we're looking at essentially a piece of evidence that wasn't before the jury, right?
Case, a couple of points to that. First, kind of the exhaustion issue would be a question of law, so that would be before the district court, but also the record was supplemented there at the district court to include the collective bargaining agreement, and you have the district court's supplemental ruling on directed verdict of March of this year that talks about how the district court relied on it in determining this legal issue. So I believe the standard would still be the correction of errors at law standard that this court applies. However, I think I would kind of push back a bit on as far as if relief is granted for appellant. I don't think it goes back for a new trial given how the district court judge handled it under the Hop rule, that it would be more of a restating or reinstating what was already found by the jury. But I think the court doesn't get there because I think, again, you run headlong into this court, the language of the grievance clause, this court's ruling in Kleppe, as well as Hartunian and Harrison. Now, I'd want to also then go back to this notion of there's inconsistency or illegality between the CBA and the collective bargaining agreement. I would disagree that this was in fact preserved. The closest we were able to find in preparing this case would be, I believe it's volume 3 of the transcript. It might be volume 2. I don't realize I did not have that in front of me, but it's at page 137. And talking about a possible inconsistency regarding payment of vacation time, which isn't really what we're talking about in this case, and certainly not what we understand the illegality to be here. And there's the question of whether this would even be the appropriate vehicle for challenging the inconsistency or any kind of perceived inconsistency between the statute and the CBA. That might be better, might be necessarily a 17A challenge. And finally, even then, the argument's still largely foreclosed again by Kleppe, where kind of the claimed conflict here isn't really a conflict. It's simply setting out the procedural order in which one has to kind of proceed for kind of one of these wage claims. And that is there at Kleppe at star 5. So, unless there are any further questions, I would urge this court to affirm the district court's directed verdict ruling based on failure to exhaust under Chapter 20 in the CBA.
Any rebuttal?
And I'm going to address the preservation real quick. And I believe it was Kleppe that this was in as well. But the idea of the legality is not a new issue. It's just another theory under whether or not he had to file a grievance with the CBA. And that is a reason why, an additional reason why. So if it wasn't addressed clearly enough at the trial court, then at this court, it really doesn't matter because it's not a new issue. It's the same issue. And then you have to look at this as of the time the violation occurred, and which is when the doctor said that he was unable to work anymore. And his leave should have never been docked if 80.64 would have been followed at that time. Trooper Eimers was concerned with not being paid at all when his leave ran out. And he knew his leave was going to run out because it was obvious that the POR board was dragging out his retirement. I could go into detail on that, but it's a very lengthy story, but they were dragging it out, and it was going to take a year and a half. And it took a year and a half. So he knew he was going to run out, and he did run out. And so way before he ran out, we filed for a writ of mandamus, and that came up here to this court, and it was decided that it was moot by the time that it was heard by the court because his sick leave bank had been reimbursed and all that stuff, and he had actually been put out on retirement. But at the time it was filed, he didn't know he was trying to make sure he kept getting his pay so he could feed his family, So that's what, part of the story. And so if you look at it then, at the time when the doctor said, you can't work anymore, there was no violation of the CBA. They had paid him in accordance with the CBA up to that point. So what is he going to grieve? And then another issue is what's going to be done for troopers in the future. Public safety has not paid one trooper or one officer under 80.64 since it was enacted. in 2010. That's been for 15 years. It's really hard to believe that not one officer has been eligible for payment under 80.64. And so Trooper Eimers just wants them to do what they're supposed to be doing and quit, skirting the issue. If they don't want to pay under 80.64, then they need to go to the legislature and have it repealed.
Just at the statute, which talks about fixed pay and allowances, how do we determine what that is? Where do we go to look for that?
Collective bargaining agreement. Just if it were one of the supervisors, you've got to go somewhere to find out what they were supposed to be paid and what their allowances were. So you would go to Chapter 70, I suppose.
Bring the claims under the collective bargaining agreement.
Just for the measure of damages. It's collateral. I mean, to the main issue and concern. It's not that it was violated in any way. It's, okay, he's entitled to his holiday pay. Well, how do you know which holidays? Unless you go to the collective bargaining agreement, or in the case of a supervisor, unless you go to Chapter 70A. You have to look for it somewhere. So that's the best I can answer that. I don't think that necessarily throws it into you had to file a grievance, because at some later point, in order to determine what your damages are, you have to refer to the collective bargaining agreement. I mean, he didn't know that he was going to have to refer to that until we were in court, basically. What are your damages? And now we've got to figure them out. And that's the only way I could think of doing it, was to refer to it. So I see my time's up. Thank you.
Counsel, thank you both for your responsive arguments today. We really appreciate that and your helpful briefing. We will consider Eimers versus DPS submitted, and a written decision will be forthcoming, and we'll stand in recess until tomorrow morning. Thank you.